as we continue on trade wars and international law. Well, Section 301 to 310 of the Trade Act 1974, which authorize certain actions by USTR, including the suspension or withdrawal of the concessions or the imposition of duties or other import restrictions in response to trade barriers imposed by the other countries, was earlier challenged before WTO. The complaint brought by the European Union alleged that by imposing strict time limits within which unilateral determination must be made and trade sections taken, Section 305 and Section 306 of the Trade Act did not allow the US to comply with the rules of the Dispute Settlement Understanding DSU in situations where a prior multilateral ruling under the DSU on conformity of the measures taken pursuant implementation of Dispute Settlement Board DSB recommendations had not been adopted by the DSB. It further alleged that the Trade Act nullified and impaired benefits accruing directly and indirectly to it under GATT 1994 and further impeded the objectives of GATT 1994 as well as that of WTO. The panel concluded that Section 304 was not inconsistent with US obligations because while the statutory language of Section 304 in itself constituted a serious threat that unilateral determinations contrary to the obligations might be taken. The United States had lawfully removed this threat by aggregate effect of the Statement of Administrative Action SAA and also made a statement before the panel that it would render determinations under Section 304 in conformity with its WTO obligations. But the panel added that the caveat that should the United States repudiate or remove in any way its undertaking contained in the SAA and confirmed in statements before the panel, then the finding of conformity would no longer be warranted. The main allegation against China is that it imposes different set of rules on the import technology, industrial property rights, and intellectual property rights than the rules which are applicable to technology transfer occurring between Chinese companies. Thus, Chinese measures discriminate against foreign holders of intellectual property rights and restrict foreign right holders' ability to protect intellectual property rights in China, which is contrary to China's WTO obligations. China further imposes restrictions on the rights of foreign intellectual property rights, the intellectual property right holders to freely negotiate market based contractual terms in licensing other technology related contracts concerning the transfer of technology to China. Allegations have also been laid against mandatory contract terms for contracts concerning the import of technology into China that discriminate against and are unfavorable for foreign intellectual property rights holders. In the context of the joint venture established with the Chinese partners, China imposes mandatory contract terms, discriminate against, and are less favorable for foreign intellectual property rights and the foreign intellectual property right holders, as well as restricting their ability to protect their intellectual property rights in China. It has been alleged that the regulations of the People's Republic of China on administration of the import and export technologies TIER are inconsistent with the national treatment principles of the TRIPS agreement. It is also required in China that all technology import contracts must be notified to and registered by the Chinese authorities, and the copies of the contracts must be provided. As under Chinese legal settings.